So I have picked this topic. Is the Malaysian judiciary progressive? Now, like it or not, the judiciary plays an important part in any democracy, and it affects our life. So I thought, um, with my background, if I can this afternoon can share my views on the how well, not my views, to inform the participants how the judiciary in Malaysia are progressing as far as their thinking. Are they being conservative? Are they being too progressive in their decision? Now, my talk will be sort of four parts. First is the introduction, and then you have separation of powers, fundamental rights, and then conclusion. My talk involves me analyzing the important cases which the federal courts have decided over the last 4 to 5 years. Okay, just a brief introduction before I start on the subject of whether our Malaysian judiciary is a progressive one. Firstly, I think we ought to know in Malaysia there are two high courts. One, the high courts of Malaya, and high courts of Sabah and Sarawak. Not many people know of this, and that's why we have a chief judge of Malaya and a chief judge of Sabah and Sarawak. And this stems from Malaysian Agreement 63, and then that's why we have it. So it is inbuilt in our constitution, which says that there are two high courts of same jurisdiction. So they are of the same level. They are not higher over each other. So that's how the constitution has framed it, and there was an agreement between the two states. Now, the other thing which I wish to sort of tell the audience is this. There are actually three arms of government. Now, what do we mean by that? We have the executive, which is sort of the cabinet, and the legislative, which is the parliament and the state assembly, and you have the judiciaries. Now, all these three arms are independent of each other, right? In other words, they exist on their own. And the only body that sort of can oversee these two, this other body, executive, legislative, is a judiciary, right? And judiciary is a body of judges given the power to interpret and execute the law. And they are the only people who are not elected like the legislative and the executive. Now, the other thing that we ought to know when we're talking about this in this afternoon's talk is in Malaysia, we have constitutional supremacy. Now, what does that mean? Constitutional supremacy is we have a constitution, and whatever law is passed must not infringe what is stated in the constitution. If those laws infringes it, it will be struck down by court. Or if the actions of the executive or anybody infringes the constitution, whatever action will also be struck down. Now, as opposed to parliamentary supremacy, now the legislative body is the most powerful one. This is like in England. England has parliamentary supremacy. In other words, whatever parliament passes is law, right? Unlike in Malaysia, if you pass a law, like I said, it contravenes the constitution, that would be ultra vires and would be struck down by court if anybody challenges. And you will see as I go on the next 40 minutes, that's what happened. Okay, how do I describe a progressive judiciary? This is the definition I got from textbooks. It's not my definition. Is whether the judiciary is willing to establish judicial power as a supervisory jurisdiction action executive. In other words, they make sure that the executive, when they exercise their power, they are in compliance with the constitution. And then the other elements of what a progressive judiciary is that you do not give it a literal interpretation. You give it a more generous. In other words, you know, legislations are passed. Some legislations are passed many, many years ago, and when you put the legislation in today's context, it would not apply. So courts have adopted the view that, you know, the law passed, let's say 50 years ago, should not be interpreted as they interpreted 50 years ago. It should be relevant to the society as it exists. And then lastly is to adopt a prismatic interpretation of fundamental right. You will understand what I mean as I go on with my lecture this afternoon. Okay, the first topic which I need to sort of start with is what we call the separation of power. I've just mentioned about the three arms of government: the judiciary, legislative, and the executive. Now here, the separation power, I'm talking about the judiciary itself. Now, with judiciary, we have what we call the basic structure, right? Now, as I go on this afternoon, you remember what the former Chief Justice has said, Raja Sansha was then Chief Justice. This is what he says: unfettered discretion is a contradiction in term. Every legal power must have its legal limits, otherwise there is dictatorship. In particular, it is a stringent requirement that the discretion should be exercised for a proper purpose and should not be exercised unreasonably. In other words, every discretion cannot be free of legal restraint where it is wrongly exercised. It becomes the duty of the courts to intervene. The courts are only defense of the liberty of the subject against department aggression. Okay, and then this is what the highest court in Malaysia says. And then it finished or said, public bodies must be compelled to observe the law, and it is essential the bureaucracy should be kept in its place. In other words, the court exists to make sure there's no abuse of power by the executive, right? And that is the law that we have in Malaysia. Now, what do you mean by basic structure doctrine? Now, this is a doctrine established in India. It says that there are certain features within the constitution that is so basic that you cannot take it away, right? Either by constitutional amendment or legislation propounded by the parliament. Even though it is not explicitly provided in the Malaysian constitution, there's certain things so basic that it must be there. It's implied in there. And as again, I will show you cases how that has been interpreted. So the doctrines provides that it is the implied restraint on the amending powers of the parliament, that is, power could not exercise to destroy or amend the basic features of the constitution. And then basic features include separation of powers between legislative, executive, and judiciary. So there are certain things that are so basic that the constitution cannot be amended to take away, neither the parliament can pass law to take away those rights. Okay, let's look at the cases. Right. Now, you look at Article 121 of the Constitution, prior to 1988, right? It says, subject to Clause 2, the judicial power of the Federation shall be vested in two high courts. That is the High Court of Malaya and High Court of Sabah and Sarawak. That's all it says. Judicial power is in the judiciary, High Court of Sabah and High Court of Sarawak. Only in the inferior courts, it will be provided by law. Now, after 1988, they changed the constitution, and it says it doesn't talk about judicial power lays with the two high courts. It now says all inferior courts as provided by law, and the high court and the inferior shall have jurisdiction and power as may be conferred by or under the federal law. In other words, what if you read that carefully, that what it means is the judiciary can only have power when Parliament says it's got power. This is what it's saying. Okay? This is what it says, the ramification of 1988 amendment. The phrase, removal of the phrase, judicial power of the Federation shall be vested in two high courts, and the inclusions of the phrase, the high courts and inferior courts shall have such jurisdiction as power conferred by under federal law. Right? Now this, after 1988, there was some confusion even in the court's thinking as what is actually that means. Does that mean that the court does not have judicial power anymore unless Parliament says it's got? Okay, let's look at the cases. Right, the first cases we sort of talk about this is the case of PP Kok Wah Kwan. What happened here was a juvenile, a 12-year-old, was convicted for murder, and death sentence was the only sentence we can pass by court. But this was prohibited by Section 97 of the Child's Act, which says you cannot pass death sentence, but it gives the power to the Yang di-Pertuan to determine the punishment. That means it's given to cabinet, right? Now the question is, does Section 97 take away the judicial power of the court in sentencing the child, right? Now, if it's taking the judicial power from the court, is it unconstitutional? Now that was the question before the court, right? Now this in the federal court, we don't worry about the High Court and the Court of Appeal, but we're more concerned what happened in the federal court. Now in the federal court, a majority of judges, that is 4-1, decided that Section 97 is constitutional because the Act of Parliament says that is the law. It gives the power of judicial sentencing to the executive, that is the Yang di-Pertuan, right? And they refer to the phrase, look at the federal law to know the jurisdiction of the power. You remember I just now talked about the amendment post-1988? The federal constitution was changed to say that the judiciary shall have powers as conferred by federal law. So the majority decision look at Section 7 of the Child Act, which says it gives the power of sentencing to the Yang di-Pertuan. Now, the interesting is, what did the minority say? The minority judgment of Tun Richard Malanjun, as he was then the federal court judge, he wrote this what we call a dissenting decision, that is a contrary view. He says the doctrine of separation of powers and independent of judiciaries are the basic features of our constitution, and the jurisdiction and power of the court cannot be confined to federal law. What he is saying is what I said earlier about basic structure of the constitution, right? So the judiciary having the judicial power, independence of any other body, is a basic a feature of the constitution. So having accepted that, that no parliament can override that basic structure, right? Now his rationale is very simple and accepted by a lot of scholars who said accepting the proposition of jurisdiction of the courts in Malaysia can only be found in the federal would be contrary to the democratic system of the government, wherein the courts function to ensure there is check and balance in the system. It was unimaginable that an amendment could be understood to render the courts servile agents of the Federal Act or Parliament, only to perform mechanically any command or the bidding of federal law. So, okay, this is the first sort of a notable case that decided whether there is a basic feature in the Constitution. Now, the next case we see is Silva Rasa case. Again, they talk about separation of powers and the basic features of the Constitution. In this case, the lawyer was an office bearer of a political party and member of parliament. He wanted to be elected to the Bar Council, but the law prohibits him from being a member of the Malaysian Bar Council by Section 46A of the Legal Profession Act. Then he went to challenge this provision in court. He says violates his rights of equality, equal protection guarantee under the 8(1) of the Constitution, and it violates his rights of association as guaranteed Article 10. So he took a constitutional challenge to the court. Now, in the federal court, this is also a federal court, there was a unanimous decision, right? It says, this is the observation made by that court. Fundamental liberties guarantee must be generally interpreted and a prismatic approach to interpretation must be adopted. Provisos or restrictions that limit derogate from the guarantee must be read restrictively. So, in testing the validity of a state action in regard to fundamental rights, what the court must consider is whether directly affect the fundamental rights or its inevitable effect or consequence on the fundamental rights is such that it makes that exercise ineffective and illusory. The fundamental rights guarantee under the Constitution is part of the basic structure of the Constitution, and Parliament cannot enact laws including that violate the basic structure. So we have another federal court saying that came after the case I just mentioned, that there is such this thing as basic structure of the Constitution and which cannot be changed, right? What is his right here is his right of association, and Parliament cannot take that right away from him, right? So having said that, but I bring you back to another case who says that because in Silva Rasa case, because the way they look at it, the law passed was it's a harsh or unjust, right? Now, there's another case also by the federal court, by Raja Arsansha. It says the question whether Impugn Act is harsh and just is a question of policy to be debated and decided by Parliament, and therefore not meet for judicial determination. To sustain, it would cut deeply in the very being of Parliament. So what the learned federal court judge is saying there, the Royal Highness Raja Arsansha, is saying that when there are policy decisions, court is not supposed to question it, okay? But the case in Silva Rasa, the federal court has said something a little bit different to what is said here, okay? And then we come to this case, which of late has every judge has used this to say that the basic structure is settled in Malaysian constitutional law. Now, what happened in this case? In this case was a compulsory acquisition case. Now, when you acquire somebody's land, you have to pay compensation. Now, the law provided that there are three persons there, the judge and two assessors. But the law provided that if one of the assessor have both the assessors have different views, the High Court judge has to follow one of them, right? So here you can see the law is such that the judge is not in a position of deciding. He's not exercising a judicial power. He has to follow what was decided by the two assessors, right? So there was a challenge here. The challenge here is the law has taken away the judicial power of the High Court judge, right? And this concerns Section 40 of the Land Acquisition Act, right? And then this is what happened. The federal court held that to award compensation is a judicial power. Now, and because it's a judicial power, and because the law, Section 40D, took away that power of the court to be involved in a decision making. So in effect, it undermined the judicial power of judiciary. And because of that, it was ruled unconstitutional. So actually, Semayat's case has been held by a lot of constitutional lawyers and says, at last, we have a unanimous federal court decision to say that, look, if you undermine the judicial power of judiciary, it'll be struck down. Here, it is quite clear. The High Court judge, right, who sat in a court supposed to, I mean, a judge is there to decide judicially. It is his power to decide. But in the Semayat case, the case I just mentioned, his power is taken away. He just had to follow. So he's not deciding. So the federal court, by unanimous decision of 5-0, saying that, no, that cannot be done. That's a basic structure of the Constitution. So that act is ultra vires. It was rendered void and then was struck down by the court. Okay? So that's Semenya case. And now what happened after that? Then we come to the a drug case, Alman Nudu case. Now what happened here? I just want to make it simple. Now, see, in criminal case, when you are charged of stealing, the prosecution have to prove that you are you're stealing. Okay. In drugs, if you're charged with trafficking in drugs, now prior to this case, if you are charged for trafficking in drugs, you do not need to prove that he is actually trafficking in drugs, because you need to prove, all you need to prove is he had the custody and control of a dangerous drug. So if he's in control and custody of a drug, he is presumed in law to be in possession of that drug, deemed to have possession and knowledgeable of the drug, right? Then the court, it can use the law to do a second presumption, that is, a deemed presumption that he is trafficking, right? So there's what we call in law double presumption. First, once you prove that the person is in custody and control of dangerous drug, he is presumed to be in possession and knowledge. And once you have proved their possession, you can use Section 37DA to make a further presumption that is trafficking. Now, the court was faced with the question whether or not such double presumption contravenes some basic feature of the Constitution. In this case, the rule of the presumption of innocence. Now, this is how the federal court dealt with it. There was a nine panel judge. In other words, there's 9 judges sitting on it, because then Chief Justice Tun Richard said it was an important matter, so we had and panel 9 judges to sit on, and all 9 judges agree. They said the act. You see, the Section 37 required the presumption to prove custody and control on the part of the accused and the way in order to establish the prima facie. The legal burden would then shift to the accused to disprove the presumption of possession and knowledge and the balance of probability. Hence, Section 37A prima facie violates the presumption of innocence, as it permitted the accused to be convicted without a reasonable doubt may exist. Now, the presumption of innocence, right, is not in the Constitution. It is something so basic and reasonable that the court says it is part of the basic structure of the Constitution. Remember, I'm talking about when I first explained to you what the basic structure concept means. This is one example of it, because you see, you read in the newspaper, you see TV, you say you are presumed innocent until proven guilty. This is a classic example to say that the law then had infringed that rule of law of presumption of innocence. All right. So again, this is another example of the existence of the basic structure of the Constitution, right? This is what the Chief Justice says. The court has on several recognized that the principle of separation of powers and the power of ordinary courts to review the legality of state action are sacrosanct and form part of the basic structure of the federal court. He also stated that courts can prevent Parliament from destroying the basic structure of the federal Constitution. And while the federal Constitution does not specifically explicate the doctrine of the basic structure, what that doctrine signifies is that a parliamentary enactment is open to scrutiny, not only for clear-cut violation of the federal Constitution, but also for violation of the doctrine or principle that constitute the constitutional foundation, right? So you would think that after this case and Semenyak case, that the basic structure concept is entrenched in the Malaysian law book. Then we have, after that case, the Maria Chin Abdullah case. Now, what happened there? As we know, Maria Chin was then a chairperson of the NGO Bersih 2.0. Now, she was awarded some sort of international humanitarian award for her work done with Dersi. And that ceremony, right, of giving her the award was supposed to be in South Korea. But when she tried to get to South Korea to get that award, she was not allowed to board the plane. And it was barred from leaving Malaysia on the ground that she had disparaged the government of Malaysia on different forums in the legal assembly. Then she challenged this ban. Then it comes to whether, because under the Immigration Act, it gives the power to the Director General, which is the unfettered discretion to impose a travel ban. So in other words, if you read that provision literally, you practically says you cannot question. The Director General says you can't go, you can't go. But having said that, you remember what I said from the very beginning, the quotation I got from the former Chief Justice, Ashlan Shah, is Royal Highness Dewas, late. He said, there's no such thing as unfettered discretion. The court still has the power to question it. Now, that was the question before the federal court. Right. Now, what happened is, now, this is the provision I'm talking about. Section 59A is very, very, very powerful. There shall be no judicial review in any court. What that means in simple language is the court cannot question the decision of Director General. Okay? Now, what happened at the federal court? Now, that decision, there were 7 judges there. There were majority of 4. All right. Remember, prior to this case, I was talking about Semenyat Jaya, Alma Nudu, and Indira Gandhi, which says the basic structure doctrine is embedded in our federal constitution. Now, what the majority says here is that no such thing. In other words, what was said there is what we call in legal term merely obiter. What that means is the judges in Semenyat's case and Aman Nudu's case did not have to rely on the doctrine of basic structure. So because of that, they said, no, we cannot, we are not following those decisions. And they said they will interpret the law as they see it. The law says there shall be no judicial review. In other words, the court cannot decide. And they go back to, remember what I'm talking about, Article 121, the amendment after 1988? The judiciary will have such power as conferred by or under the federal law. So you read that, the majority is just, it's correct. It says that's what the law says. Now, what did the minority do say? The minority, which the Chief Justice was part of, they said the supremacy of the federal constitution, Article 4.1, and the coroner device of judiciary are basic structure to the federal constitution. In other words, the judiciary exists to exercise judicial power to determine disputes between state and its citizen. In other words, you cannot say, you cannot pass a law to say, oh, sorry, the courts have no power to question the decision of the Director General of Immigration, right? And then it says, no such thing. In other words, it says that provision and law has infringed some basic feature of the federal constitution. And it says that the rule of law stands as only a whimsical notion to decorate textbooks if there is no appropriate and effective means of enforcing it. In other words, there's a thing called rule of law. I don't know whether you remember or not. Tun Richard was a lecturer from last year, talk about the rule of law. I mean, the rule of law is very much part of the federal constitution, as pointed out by Tun and as pointed out by the present Chief Justice. So the minority of the Chief Justice and then Justice Nanini felt that that ouster clause was unconstitutional. But what had happened there in the minority, and then that is, I understand, is the latest case which deals specific about the federal basic structure. Now, what do we take away from it? Now let me just show you what had happened, right? Remember the first case? It was a majority 4-1 to say there's no such thing as basic structure. Then come another case in Civil Rasa, unanimous decision of 3 judges who says there is such a thing. And then you come Siminya, then you have a unanimous decision of 5 judges. And then the next case, you got Almanandu, which has 9 judges saying that there's such things as a basic structure. And then you have number 5, Maria, which had 4-3. Right. What do you take away from it? Is the concept of basic structure a settled concept in Malaysian judiciary? I leave that to the lawyers to think about it, and then ask yourself the question is, should we have the basic structure concept in the Malaysian law? Is it a progressive thought, a progressive thinking, or should we just take the conservative view? There's no such thing, and we read the words as they exist. Okay. Now the next part is I will be talking about some fundamental rights. Here, the right to livelihood, freedom of speech, and then deprivation of rights, and then citizens' rights. Okay. Now the first thing, fundamental. I mean, why is it important? Well, of course, it's important to all of us, right? I mean, we need some. We live in a democracy. We need some basic rights. I mean, right, the freedom of speech. I mean, I can say whatever I want as long as I don't defame. I have the right of religion and all that. So it is important that we have this right. And who can protect us? Only the courts can protect us, right? Okay. What's the first case that we have? This is the, I think the first case which talk about the fundamental right to livelihood, right? In this case, what has happened is that person got dismissed by Hong Leong Equipment Center Berhad. Under the law, if you complain to the minister can decide to refer to the industrial court. Now, in this case, the minister refused to refer to the industrial court. In other words, I'm the minister. I don't think there's any thing I should refer there. Okay, but the court took this approach. Now, when you question the minister right not to refer to the industrial court, now you must look at that together with somebody's right to livelihood, right? You know, we all exist we have a right to work. We have a right to earn, to make a living. Now, this is the first case where the federal court says there's this thing called the right of livelihood. And this right of livelihood is a fundamental guarantee, liberties guarantee within life under 5.1 of the federal constitution, right? So having said someone's livelihood is a constitutional right, now you have to look at that and put it next to whether the minister have exercised his power correctly. So because of this fundamental right entrenched in the constitution, you cannot just say, the minister is correct. So the court then, using that concept of fundamental right of livelihood, then look at the minister decision, whether it is a reasonable one, whether his decision is reasonable or perverse or whatever. It is not a question, is you can't look at it anymore. You can't look at it, right? Now, it says, so that is the first case. So right livelihood. So, you know, I think after that case, the courts began to take more serious consideration about fundamental rights in the country. Okay, the next right is freedom of speech. Right now, the case which here I have to make a disclosure. I was one of the judges at the Court of Appeal in respect of this case. Now, this case is interesting. Now, this is a state assemblyman and a member of parliament who alleged certain things about the Sarawak state government has been mismanaged and all that. And then the allegations were published in the political party's newspaper. Now, the government of State of Sarawak and State Financial sued the State Assembly for libel. All right. Now there is this principle called Barrister principle. The Barrister principle is a principle which emanates from England. It states there, a government body do not have the right to maintain an action for damages, for defamation, as it would be contrary to public interest for the organs of government to have that right, because it is of highest importance that a government body should be open to uninhibited public criticism, and the right to sue for defamation would not only have a chilling effect, but would also place an undesirable fetter on freedom of speech. So what happened there is the High Court rely on this principle and says, look, you can't stop people from saying, even though it may be defamatory, but we're talking about government here and not an individual, right? So what has happened, the High Court says, no, the freedom of speech, the Barrister principle applies, and ruled that the government's was incorrect. But when it went to the Court of Appeal, the majority held that because of Section 3 of the Government Proceeding Act, it gives a right to the government to sue. And then the Barrister principle is just a common law right, which stems from England. It doesn't apply to Malaysia. So by a majority of 2-1, it says the government can sue individual for defamation. The minority, of course, is myself, and I just rely on the Barrister principle. Now, I actually asked this question: could one really say the government have a reputation per se? Government of the day were made up of members of a winning political party, and their reputation or popularity fluctuate due to numerous and various reasons. It could not be disputed that the government of the day might be so popular due to the implementation of particular policy that no amount of defamatory utterance could dent its reputation or popularity. How do one measure or determine that reputation? So what I'm trying to say is, a government is not a natural person. So how do you dent its reputation? But anyway, mine is only a minority decision. It went to the federal court, and the federal court, of course, agreed with the Court of Appeal's decision, and it says any government authority can sue for defamation, right? Because it's provided there, and it says the Barrister principle doesn't apply to Malaysia. Okay, after that case, we have other cases. This case is the Lim Guan Eng and suing Rashan Kashim. Now, the interesting thing about this case is that the MP, who was then the CM of Penang, tried to sue this person, right? And then, of course, the other persons rely on the Barrister principle that government officials cannot sue individual, right? And then what happened there was that it then also went to the federal court, but the federal court did not rely on the Barrister principle. It said it does not apply here. Here, in this case, the MP was suing on an individual capacity as a private citizen, and not by the office of Chief Minister of State Government to his reputation. So in that sense, this case is different to the previous case I mentioned, and the federal court found that was not applicable. But what is of interest in this case, the judge wrote this. Justice Harminder Singh, he wrote this in that judgment. The elected government authority owes its very being to voting citizens upon whom it is now sought to recover damage of defamation. It was irreconcilable, a fortiori, that a government litigation against its own citizens be funded by those very citizens who contribute to their office. Such government authority already enjoy easy access to the media. It would be easy for the authority to ensure that its rejoinder were well reported in the media. Further, in the case of an elected authority, to say that it had a governing reputation was awkward as the authority would be temporarily controlled by one political party or another. The reputation is really that of the governing party. So that of interest was interesting, said by the federal court judge, even though they were not dealing with the Derbyshire principle. Now, the next case is of interest as well. Now, in the next case, unfortunately, we don't have the written judgment. This is the case where the MCA Secretary General sued by defamation against another member of Parliament concerning his press conference saying something bad about the political party MCA reputation. Now, he sued, asked for 100 million. Now, the High Court, in the High Court, they tried to strike out the case. Lim tried to strike out the case, and it was not successful. But that decision upheld by the Court of Appeal. And then on the ground that political parties have a reputation. Now, it went to the federal court. Then federal court, there was a 7-member bench chaired by the then now president of Court of Appeal. They set aside the decision of the High Court and Court of Appeal and says that the MP's application to strike the suit was correct, right? They're saying in this case that political parties have no reputation. Now, this is what I'm quoting here is actually a report from the newspaper, so I have to make the caveat because the grounds are not available. The federal court adopted the decisions of the council, which is Corpus Ram. He said, the government and political parties, being registered society, cannot maintain a cause of action in defamation, as societies and government have no reputation. The law of defamation protects the reputation of persons. And the federal court had wrongly decided in the case involving Sarawak government against Sarawak DAP chairman Chong Cheng Cheng, where the federal court ruled the government could sue individuals for defamation. Now, what have we got now? It seems that what is the thing and takeaway here? It seems that we have one federal court decision saying that the government can sue for defamation. And then the latest decision, which is also the federal court, it says you can't. Again, to me, there are grounds to saying that the law is unsettled here. Again, what I've got there is what I've said before. I just, what I said earlier, saying that can a government have a reputation, right? If government has no reputation, how can you sue for defamation? Okay, that's about on freedom of speech. How am I going with time? Am I okay, or somebody's going to tell me? Okay, I think I'm okay with time. All right, deprivation life. This is another section area I want to touch on. This again here is somebody dying in custody. Now you read in newspapers some of the remand prisoners die during custody. Now what happens is the estate starts suing the government for negligence. Now we have a law in Malaysia under Section 8(2) of the Civil Law, which says that if the estate is suing on behalf of somebody, you cannot have exemplary damages. Now, exemplary damages in simple terms is damages to punish the wrongdoer. It is over and above the usual damage which you get. So this Civil Law Act has a specific provision to say you can't sue for exemplary damages. Now, what happened here? In this case, the estate of the deceased did sue for exemplary damages. Again, they read the law as it is and say that you can't sue for exemplary damages. But for in a minority decision, there's a minority decision of Justice Nalin Pathamaran, was this, because here the right to life is a constitutional right, right? So when you breach somebody's constitutional right, different consideration apply. So the Civil Law Act, which I showed you just now, should not apply because we're talking about somebody's constitutional right. And how basic it is when you're talking about somebody's right to life. Somebody's life's been taken away. So the dissenting judgment took a different point of view to say, look, Civil Law Act doesn't apply. So you should, the court should be allowed to award exemplary damages, right? Unfortunately, I mean, that is so. But what have I seen lately was that instead of giving exemplary light, they're giving exemplary damages. They're giving another sort of damages, and the federal court have jacked that up. Give much more damages to reflect actually the amount, reflect the exemplary damage which they would have given if they wanted to do. So I can see they are seeing the injustice of saying that you can't give exemplary damages, but they're giving compensatory damage much higher than usual. So again, this is the contrast between a progressive view, an example of a progressive view, and sort of a conservative view. Here, the progressive view is that yes, there is a provision in law that to say you cannot give exemplary damages, but how do you get around it? The Justice Stanley took this way. When you breach somebody's fundamental right provided in the Constitution, that law cannot apply because you're talking about another, so to speak, another animal, if I can put it that way, another creature. So that you can say, I mean, commentator will say that is a progressive view in interpreting legislation. Okay, that's again. Now the next one is citizenship rights, which I think have been published late. See, under the Federal Constitution, Article 14, every person born before Malaysia Day who is a citizen of Federal is a citizen. And then every person born on or after Malaysia Day and having a qualification in Part 11 of the second schedule are also a citizen. Now, there are several cases on citizenship right. The first one is this. This is CTEB and the Registrar of Birth and Registration. Now, here, the child is a legitimate child in Philippines, but born to a Malaysian father and a Filipino mother. Now, at the time of birth, the father and mother were not married, but they were married 5 months later after his birth. So he also had a passport from the government of Philippines. So the appellant then the father and the child went to court to ask the court to say, hey, I'm a Malaysian citizen by operation of law because I was born in Malaysia. I was born to a Malaysian father. Okay, both the lower court, the High Court, Court of Appeal reject the application because they were born out of wedlock. In other words, they were not married then, right? And the law says you must be married and at the time of birth. Otherwise, the law does not give you citizenship. So the federal court then held, next picture, this again by majority, that just because the father and mother married after the birth does not allow them to get citizenship. The relevant time was at birth, were they married or not, right? So that's how Article 14 was framed. So if you read it as it exists, you could say the majority is correct because that's what it says. But let's look at the minority. Now they took another view. They said, hey, that means you are discriminating against a child who was born out of wedlock and it's not his fault, right? So that's how the minority look at it, right? It says, look, we must interpret the law in a way that ensure that nobody is discriminated, right? I mean, it's quite clear to anyone looking at it, is that because he was born at a time when the father and mother were not married, he was not entitled to a citizenship. But the minority says that is discrimination, right? And because of that discrimination, right, they interpret in such a way that the child is entitled to citizenship. Now, so here they use another legislation which says that you must interpret the constitutional in a what expansive sense, in a broad and liberal sense, and then it must be interpreted in such a way that it is harmonious with the other provision. The other provision, it says everybody is equal before the law, right? Whether it's illegitimate or not legitimate. So again, people who write articles on constitutional law, you can say the minority decision takes a progressive view in coming to a decision. Okay, the next one. The next one is the stateless person. Here, the couple then decided to adopt the child, and what they did was that when they adopted the child, when they fill in the form, they said they were the natural father and mother, but unfortunately they were found out, and then they had to withdraw that fact that they were the biological parents. So they gave back the first certificate, the previous one, then they surrendered the first birth certificate, and then the second birth certificate was issued 2016 and stated the child's parents were not available. So nobody knew who the child was. It is a fact that nobody knew who the child was. And then it says yet to be there. So what the couple did was they went to adopt the boy, and then the court allowed them to adopt. And then again they went to get the third birth certificate, and the birth certificate states that bukan warga negara, so not a citizen. So they again went to court to challenge this. So this is what happened in the federal court. Now, this sort of person is what we call a stateless person. Now, what the federal court did was this. They said, provides that, they're looking at section 1A, that every person born within Malaysia, at least one parent being either a citizen or permanent resident in Malaysia, to be saved by operation. Being a citizen by operation means only one is entitled automatically under the law to be a Malaysian citizen without having applied for citizenship. So, and then you look at another section, provides any new person born found exposed in any place. Now, this is important. Exposed in any place shall be presumed to have been born to a mother permanent resident there, right? Okay. So here, again, the federal court says citizenship is a right to life and personal liberty under the Constitution. Here again, you're looking at the right of the child. That's how the federal court is looking at it. And in this case, what has happened here was that nobody knew where the mother was, right? If you next slide, please. No one knew where the mother was. So, but the adoption was done in Malaysia, right? So the federal court held that it is on the burden, on the Registrar General burden to prove that, to investigate the status of the biological parents of the child or the mother, right? Because the presumption arises because you took the child from a hospital in Malaysia, so you presume that the mother was also a resident in Malaysia. So because of that presumption and putting the burden on the Registrar General to prove that the mother is actually a foreign citizen or whatever, then, and in that case, there was no contrary evidence to prove otherwise. So the federal court held out that child is a citizen of Malaysia. So this is, I think, the first case in Malaysia that's given citizenship to a stateless person. And I'm sure there are a lot of this sort of stateless person in Malaysia. So this decision is of most important. Now, this is the last case I want to refer to. This is, I think, is this is a decision of the High Court, and I think those who are interested in this area of law would know very well about this court, about this case. As we all know, if you are a Malaysian mother, right, and you have a foreign husband, and if the child is born outside Malaysia, you are not entitled to citizenship because you are a woman, right? Now, what happened in this case? Next slide. The child was born to a Malaysian mother outside of Malaysia. The child contended that the impugned provision is discriminatory towards mothers who are Malaysian citizens whose children are born out of wedlock, born out of a federation, because the impugned provision only confers citizenship to children born out of the federation to fathers who are Malaysian citizens. Now, you see what that means? If you're a Malaysian mother, you have your child outside Malaysia, that child is not entitled to Malaysian citizenship. But if you are, if to fathers who are Malaysian citizenship, in other words, if the father is a Malaysian citizen, there's no issue. But in this case, the father is a foreigner. So you see the discrimination here. So if the citizenship is a father, there's no issue. If it's a mother, there's an issue. It's not automatic citizenship. So what did the court do? The court looked at Article VIII. Again, they did not. If you look at the provision in the Constitution and the words used, it's quite clear. If you're a Malaysian mother and the child born outside, too bad, you don't get citizen. But if you're of a father, there's no issue, right? Now, the court says, in this case, the impugned provision reflects provision of equality before the law and equal protection as provided for under Article VIII. Here, the High Court looks at the other provision of equality below the law. Here, it is quite plain. It is discrimination between male and female, husband and wife, right? So the High Courts look at this way. Because of this contradiction, right, the only way to harmonize it is to say that that provision has to make way for the other provision, right? So the court's rationale could be summarized like this. On the point of legitimate expectation, the argument is that the country has ratified international treaties and conventions intended to give equal rights without consideration of gender. To me, this legitimate expectation is not derived from any international treaties or convention. This legitimate expectation of mothers in this case is derived from natural instinct to give the best to the child. It is only natural that a parent desires that everything of value be inherited by their children, be it material or otherwise. The federal constitution is therefore to be interpreted to meet the needs of current times, and theory of this interpretation is called the organic theory. Okay. Now here again, we see example of a judge, right, taking what I've been saying, a progressive approach to interpreting the law, right? I mean, we're living in a society or at an age where we cannot discriminate between genders. We talk about gender equality every day, every minute see on television. So this is how the court has approached the whole thing, right? And then of course he refers to the case I just mentioned about the illegitimate child, and this is what he says: the question of this decision raised is Does this mean children born out of these illegitimate liaisons of our federation will be granted automatic citizenship following the citizenship of the mother? This will give rise to ignominy that the rights of children born out of illegitimate liaisons are above those born out of legitimate liaisons. So this is what the High Court judge. Okay, so in coming to conclusion, after having analyzed this case, I think I leave the audience to answer, do we have a progressive judiciary in Malaysia, right? And if not, why is it so? And if not, why not? And the question, I think everyone asks, I mean, the lawyers and people are like, is it more beneficial to the country, to the citizen of Malaysia, that we have a progressive judiciary? So that is a question I think lawyers should ask. And for myself, when I was a judge, I continue to ask myself every day when I'm writing judgment. On that note, thank you very much. I'd be most happy that. I also like to say thank you to my team who helped me to prepare this. Chantal, Janice, and Joshua, and of course, Janice is helping me to do the slides. Thank you very much, guys.